Dear friends, welcome to this new video of my YouTube channel about the legal perspectives in which we discussed various law issues but try to look from a different perspective. This time I decided to talk about or to delve into the issue of judicial delays. It has caught my mind because आप सबने महसूस किया होगा, ये आपका अनुभव भी रहा होगा अपने अधिवक्ता न्यायाधीश या समाज के जब भी लोग जहां न्यायाधीश और वकील साथ साथ बैठते हैं उनसे अक्सर ये सवाल पूछा जाता है कि वकील साहब, जज साहब, आफ्टर ऑल ये मुकदमे इतने लंबे क्यों चलते हैं? एंड नोबडी हैज इजी आंसर्स और हम लोग सब दाएं बाएं झांकते हैं सवाई जवाब देने के लिए. देयरफॉर आई डिसाइडेड कि व्हाई नॉट टू डू समथिंग serious on this issue. That's why I am before you. But before I actually start to talking on the issue of judicial delays, I shall try to draw a remote analogy between two diametrically opposed things. One is the issue of removal of poverty and the other is judicial delays. Removal of poverty or poverty per se has long caught the minds of the thinkers, economists, politicians, policymakers, especially after the end of Second World War and the advent of the new economic order, where all people sit together to do something to at least alleviate the poverty, if not eradicate it. For this purpose, there were academic chairs, there were symposiums, there were debates, scholarships, so much so there have been a couple of Nobel Prizes on the study of poverty. But the poverty is something which refuses to go away. Looked from this angle, it is my belief that the judicial delay in itself is a mammoth problem which need to be addressed from all angles. Therefore, I myself did some research which I shall put before you and then you make up your own mind. Okay, where exactly the fault lies. I shall start this video from an article published in Times of India sometime in 2010 by Justice V.V. Rao of the Andhra High Court, delivering a lecture on e-governance conference. He calculated that there are 35 million pending cases in various courts across the country, and given the number of strength of judges, the legal infrastructure, it may well take 320 years to decide all those cases. He also delved into the per capita availability of judges and various other factors. It was followed by, in 2014, another news item in the Hindustan Times, which said that what is required is the 50 judges per million population in India. And compared to other countries, this is woefully low. And other facts mentioned in that report were almost same, except that the number of pendency cases was different. My second attempt to delve into this problem was a study of the national litigation policy, which was framed in 2010. There again, the various issues, various aspects discussed were all the same. The increasing and unnecessary proclivity of the government to litigate, poor infrastructure, the number of judges per capita population being woefully low, and the conduct of lawyers and the other stakeholders. Nothing new was either envisaged or conceived except the accumulation of basic data. Then there was another policy, national litigation policy in 2014, which was almost ad verbatim repetition of the old policy. No new facts were mentioned, except that there might have been slight change in the number of pendency of cases and some changes in the number of judges. But the underlying thread behind all these was the government should be more circumspect in litigating, because the government being the biggest litigant must take extra care to ensure that no unnecessary appeals are filed, or once an order is passed in favor of some petty poor litigant, especially government servant, so no appeal should be filed. It must also be taken into consideration or kept in mind that just because the order may affect larger number of persons, putting an extra burden on the exchequer should not be the factor behind filing of appeals. It should also be kept in mind that the other factors, such as if there is only just single individual, his misery can be ignored. If there is already existing law on the subject, why should the government try to agitate, re-agitate same issue before the same courts? That should also be kept in mind. The salient features of the national litigation policy are almost all the same, which have already been on the book on the recommendations of the various recommendations. Most importantly, the entire litigation policy or all the research work done does not mention anything, any recommendation of the National Law Commission, which have submitted reports after reports. This fact in itself is very surprising, that you have Law Commission headed by Supreme Court judge, but his recommendations are seldom or even rarely taken notice of. Next, the most hilarious aspect of the two litigation policies is that having been published in 2010, repeated in 2014, again came to notice in 2023. But there was a Hindu report published in 2023 that even after 13 years, the national litigation policy remains in draft limbo. Means that there has been policy, first policy, second policy, all gathering dust. No concrete action has been taken by the authorities concerned. That, of course, is none other than the Government of India. And if ever such a policy was ever shared with the respective state governments, it is not found on record. It is not in public domain, so therefore I don't know. After all, state governments are equal stakeholders if ever any policy worth the name is sought to be implemented. After that, there was an article by one Vandana Ajay Kumar of Punjab University. She definitely did some intensive work, detailed research, but as you will see on the screen, that all her work is confined to accumulation of data, which is already been discussed in the new litigation policy, the number of judges per capita population, its comparison with the other developing countries. In our country, it is just about 10 per million population, and it varies from 14 to 71, starting from England, Germany, France, Canada, and US. But we remain at the same stage of the 10 judges per capita population. The other aspect considered in this academic paper are the behavior of the judges, behavior of the lawyers. It is mentioned that lawyers and litigants always have a extra or vested interest in prolonging the cases, because once a plaintiff has sought an injunction or obtained a stay order in his favor, he will never be in a hurry. And judges, showing that they are already overburdened with huge number of pending cases, cannot pay special attention to redressal of each issue. So much so, only recently, the Chief Justice of Madhya Pradesh High Court did try to evolve a policy that from now on, in the lower and district courts, all those cases which are 5-year-old shall be given top priority, and they shall be D-Dem, day-to-day hearing. There was a huge outcry by the lawyers, long drawn strike by the lawyers, saying that this special treatment to old cases will take a heavy toll of their existing present cases, and they'll not be able to procure any relief if all those new cases are relegated and only old 5-year-old cases are heard. The matter went for too long. It is no doubt true that yes, lawyers themselves have much to account for, but what about the approach of judges? In all these papers, starting from the article of Justice V.V. Rao in 2010 to the Hindustan Time report in 2014, then National Legal Policy of 2010, 2014 and 2023, no attention has been paid to the approach of judges. I can understand Yes, we can't comment on the conduct of judges. But commenting on the conduct of judges is one thing, but to observe their functioning in court is quite another. Without any attempt to denigrate the majesty of judges, one can always do a very objective analysis of their way of conducting themselves in court. That is, all my friends, my colleagues who have been practicing in high courts must have observed that there is a vast difference in the disposal of case by each judge. A judge sitting in court number 1 named A may decide as many as 150 cases in motion hearing in say 2-3 hours. But a other judge sitting in an adjacent court may be stuck up at 10 or 15. Has there ever been any performance appraisal audit of the disposal of each judge? I don't think any such data is available in public domain. Therefore, the main thrust of my video is to have a fresh look, objective look at the way the judges conduct their courts. And is there any possibility of eliminating unnecessary delay? How much time must be granted to each case at motion stage or final stage? That must be that can be mathematically worked out. So, when I said that there is a vast difference in the judicial output of the judges of the same court, I have a very interesting anecdote to mention, which I read in the memoirs of one of the most eminent legal luminary of this country, which this country must be proud of, Shri Fali S. Nariman. In his memoirs, he has mentioned a matter. Anyway, before I come to that story by Mr. Nariman, let me make it very clear that the rules of procedure, civil procedure, remain same for last most 100 years, except of course just before we are told that some new Nyaya Sanhita has come into existence. Whether it has been notified or not, I do not know. But the story that I am trying to mention was of the same period when the present civil procedure code was in vogue. Yeah, had already come into practice subsequent to the recommendations of the British judicial system, which was implemented in India in the latter part of 19th century. One more thing I try to point it out, that there's no doubt true that our procedural laws are definitely very tedious, very time consuming. But the basic purpose, if we have been told or taught a student of law, is to ensure that each and every individual litigant who comes to a court must be given a fairest possible hearing. And perhaps that is the reason. And the story which I am going to narrate happened when the rules of civil procedure were already in practice. The story goes that a Scottish judge posted in Bombay City Civil Sessions Court in the third decade of the 20th century, Norman MacLeod. He was specialist in commercial cases. When the suit was filed in his court and written pleadings were complete, he will give 3 minutes to each of the parties to address their issue. When both the parties have addressed for 3 minutes each, then he will pose 2 questions. Okay, what was the market doing on that day, going up or down? And second question, whether the person seeking relief is the plaintiff or defendant. Having heard the answer to these 2 questions, he will pass an order, suit decreed or suit dismissed. The whole thing could complete in barely 2 days. And look at the confidence which the judges of that time inspired among the lawyers, the litigating community. Nobody had ever doubted the integrity of the judge. So, what has led to this long judicial delay is an increasing loss of trust and faith in the judicial system, both of the lawyers and the litigating public, wherein judges themselves are under pressure to offer more and more maximum opportunity of hearing in the name of fair play, or what may be called as principles of natural justice. But I am sure if the judges of same caliber as was Judge Norman MacLeod could be appointed, this long, arduous trial of proceedings could be curtailed. As I have narrated the tale of long judicial trials, time-consuming proceedings, in my next video, I shall make a case study of two cases where you will see that a literally non-issue, literally open and shut case, which required no adversary adjudication, could drag on for 25 years in various courts in India. And thank you very much. Please, if you like this video, share it, subscribe it, and press the bell icon so that you get the new notification. Thank you very much.